Hello, my name is Natalia Porsche and I am an immigration attorney here in the United States. And in this video, I will discuss how to change your status from, let's say, a B visa to F1 visa. So let's say you are here in the United States on a B1 or B2 visa, and you're thinking about enrolling in school, let's say full-time in school, you're thinking about getting F1 visa. So what you will have to do is you will have to change your status from B1, B2 to a F1 visa. Now, you have to remember, first of all, very, very important that you cannot have a preconceived intent. What is a preconceived intent? Preconceived intent is that when you contact, let's say, the school, before 90 days expires after you enter the United States. What does it do? Well, what it does is it shows that you did not have your intent to come here in the United States on a tourist visa, that you had intent to study here in the United States, and you misrepresented to your intent to, let's say, to a counselor or abroad or to the admission officer when you was entering the United States, and a CBP officer asks you about the intent, why you're coming here into the United States, and you stated, well, I'm coming here on a tourist visa. And let's say in reality you contacted the school 1 week after you entered the United States, and so now there is a record that you was speaking with school before 90 days 90 days pass here in the United States. So that shows preconceived intent. That shows that your intent when you entered the United States was not the intent to enter it on a tourist visa, but intent to study here in the United States. So you have to be very, very careful when you contact school before 90 days expires since you enter the United States, and now you are thinking about changing your status from a tourist visa to a B1, B2 visa to a F1 visa, a full-time student visa. Now, it's very important to know that you cannot study here in the United States if you're on tourist visa. If you're on tourist visa, you're here as a tourist, not as a student. Also, the adjudication time can be anywhere from 11 months to 13 months. It's a long time, and you have to keep in mind that during your waiting period here in the United States, you cannot study, definitely not. You cannot work unless you're here on a different visa. Let's say if you're here on, let's say, for example, H-1B visa, then if you have work permit, yes, of course you can work. Now, but if you don't have any kind of other visas and you are here just on the tourist visa, obviously you cannot study, you cannot work. So you have to think about what you can do here in the United States during this 11-13 months while you're waiting for your student visa to be available. Also, it's very important to know that obviously you cannot travel while you're waiting for your tourist visa, because then you're traveling outside while you're waiting for your student visa and you're traveling outside of the United States can create a problem. Because if anything happens, you will have to go to a consular of processing abroad, and then if you go in front of the same officer and you ask for a student visa, the officer will say, okay, well, you've been here before, you asked for tourist visa, now you're asking for student visa. So what happened in the United States? Why are you asking for that visa? So now the officer will assume that you misrepresented the intent why you're coming here in the United States, or why you came here to the United States. So that will go likely against you. And let's say if you are from a foreign country, let's say somewhere in Eastern Europe, then where the pay will be substantially low, the average pay, and now they see that you come into the United States on a student visa, which is non-immigrant visa, so they can think about that you might want to stay here and work, so likely the denial rate will be much higher. If you're under those kind of circumstances, then of course it's probably will be more beneficial if you stay here in the United States and wait this 11-13 months for your visa to be available. Also very important to know, so what kind of documents that you have to file. Let's say you want to change your status here and you came here on B1, B2 visa, now you change it to F1 visa. So what kind of status you will have to, what kind of paperwork you will have to file, and what do you have to show to the USCIS? Well, first of all, of course, you have to file Form I-20. You have to file your personal statement, is very important. So personal statement of why you want to study here in the United States. So that's why you probably need to speak with a lawyer, and lawyer can help you with a personal statement, because majority of people, they have limited foreigners, they have limited English language. And not just that, the lawyer can direct you what is the main points to hit in your letter, what is the very important things to show, and of course the lawyer can consult you about 90 days period as well. Also, you'll have to show your admission letter. You'll have to provide your admission letter from school with a course that you will be studying, and school will do everything for you. They have very experienced people working there, and they know exactly the process. Also, you'll have to show the proof of maintenance that you was maintaining a lawful status here in the United States. Let's say that your status did not expire before you applied for extension, right? Before you applied to change your status here in the United States. Very important that you were on lawful status after you entered the United States on non-immigrant visa. Also, you cannot have, let's say, petition I-130 or I-140 pending, because petitions or be a beneficiary of I-130 or I-140 petition, because those petitions are immigrant petitions. They usually are filed by a U.S. Relative or a permanent resident family member to adjust the status of the beneficiary. So however, you can be derivative beneficiary of that petitioner. Let's say if you are a child of the beneficiary who are the beneficiary under I-130, if you are a child under 21, yes, that doesn't apply to you. That's okay. You still can apply for a student visa. But however, if you are the main petitioner, if you are not the third party, the main beneficiary, then of course you cannot have a non-immigrant application, student visa application pending, and also I-130, which is an immigrant visa, because it gives the USCIS a wrong impression while you're here in the United States. So Form 539 is the form that you will be filing to change your status. This form is available on USCIS website. Also, very important to know, I have a lot of questions about TPS, how TPS affects the status. Well, really, TPS has no effect on your student visa, or it has no effect on any kind of other non-immigrant visa. If you have a B visa, you still can have TPS. You still can apply for TPS and you can have non-immigrant visa. TPS has no effect whatsoever. Remember, you cannot travel with that. And applying for advanced parole would be probably not a smartest idea here. Also, asylum applications, they're kind of asylum applications, U visas, they're different creatures. They are not really, they cannot be really even it's a separate issue. Let's say the asylum application under the statute, they are adjudicated separately. U visa, of course, it's an immigrant visa. So again, here you cannot really have immigrant visa and non-immigrant visa pending at the same time, because USCIS again will have a wrong impression while you're here in the United States. Of course, USCIS will look at your prior immigration violation and criminal violations. If you have any DUIs, if you have any misdemeanors, if you have any felonies, of course, very important. That's why you need to consult an experienced attorney to speak with about this is at least 4 different things you will have to consult with an experienced immigration attorney before you decide to file for a change of status. It's first of all, of course, the 90 days, what you have told to school, if you have contacted previously school before 90 days expire here in the United States, what you have told CBP officer when you entered the United States, what you told the consular processing officer abroad when you was receiving your non-immigrant visa, tourist visa. So you can consult attorney about that. Also, if you got any DUIs, if you have any misdemeanors here in the United States, little violations, also good thing to speak with an attorney. And of course, it's a personal statement. I would strongly encourage you to contact an experienced immigration attorney to discuss your personal statement with your case, and to make sure that you have everything to change every document that you need in order to successfully change your visa. Again, remember, adjudication period is 11-13 months. You cannot work in the United States, and you definitely cannot study. If you have any questions about this video, or you would like to consult with an experienced immigration attorney, you can contact my office by calling 228-229-7500. I hope this video was helpful. If you like this video, put thumbs up and subscribe to my channel, and I have more videos coming. Thank you for watching.